You hear me okay? Is this thing on? Thank you everybody for joining us. I guess if we can get those doors closed so there's not a whole lot of noise, maybe somebody can do that real quick. So I am Candice Brower. I'm the regional counsel for the first region of Florida. Before that, I worked for the regional counsel since they were created back in 2007. I started when our office opened in Gainesville in 2008, and I started just handling some delinquency cases there and did some dependency cases, and then came on full-time and did a little bit of everything. And I was appointed by the governor in 2016 to lead the agency, but before regional counsel, before they even existed, I had my own practice, and I was on the registry, and I did dependency cases, criminal cases, delinquency cases, and any other case that would walk through my door and give me some money. And then before that, I was a prosecutor for the Third Circuit of Florida. So, and that was way back in, I'm not going to say when I graduated law school, but so I've been doing this a little while, and of course everybody knows what due process is if they're a lawyer, but before we get into all of this, we kind of want to know who we've got here, and I also wanted to let you know who I have with me, which is one of my assistant regional counsels, Chadsey, and if you could tell everybody a little bit about yourself, and then we'll find out who's here.
I joined the Office of Regional Counsel about a year ago. Prior to that, I worked for the Department of Children and Families, Children's Legal Services for 4 years. Prior to that, I was a court-appointed special advocate for the Guardian Ad Litem program down in Sarasota County. So my entire legal career has been working with dependency, working in the dependency system. I love being an advocate in all aspects of the dependency system.
So, if you all could let me know, how many parent attorneys do we have here with us? A couple, a few. Okay, we've got some, and then I know we've got some CLS attorneys because I did see a couple. We got some. Okay, there they are. Guardian Ad Litem attorneys. All right. Are there volunteers and staff also in the room? Okay. And do we have also caseworkers, family care counselors, any members of the judiciary? Okay, and is there anybody else that does something I didn't mention? What? Actual Guardian Ad Litems? I thought I said volunteer. Sorry if I did. Okay. All right. And what about out of everybody in this room, if you could raise your hand if you yourself are a parent? A parent. Do you have children? And and some of you, I imagine, are parents of minor children still, right? Okay. All right. Well, that was really important for us to know. And why don't you go ahead and, because go ahead and tell them what due process is. I'm going to let Rachel do the first slide here.
So the reason we ask who all are parents in the room, the reason why we're talking about due process today, is because it affects everyone. It affects your fundamental right as an individual to raise your children free of state interference. That affects everyone. What is due process? At a very basic level, all the attorneys in here know what due process is. At the most basic level, it includes notice and an opportunity to be heard about a certain issue. In the context of dependency, we're dealing with a fundamental right protected by the 14th Amendment to parent your child without government interference. Because of this fundamental right, the state must provide due process when they seek to interfere with parenting your child.
All right. So obviously we all want to know, why is this so important? Why do we care about, do I hold it this way? Mm-hmm. Okay. Why do we care? First of all, who does due process apply to? Does it apply to just people in the legal system, or does it apply? Thank you. Yes, of course. Due process applies to everyone, and we want it that way for a reason. We care about this because as citizens of this country, or even not citizens of this country, when you're in this country, you have a right to due process, and because we all have certain fundamental rights, just like in a criminal case. So I like to relate this to a criminal case because I did start my career as a criminal lawyer, and one of the most important things, of course, to us as Americans is our fundamental rights, our freedoms, our liberty interests. So just like a liberty interest in a criminal case, parenting is a fundamental interest that cannot be interfered with without due process of law. So I like to say what happens in a criminal case if due process rights are violated. And this is a very easy thing. I think most of the lawyers know what happens when the court, an appellate court, decides that a defendant's due process rights were violated. What happens? Gets overturned, sometimes remanded, sometimes you have to go back to the drawing board, sometimes you don't even get another shot. So how is this different in a dependency case? This is true, but the correct answer is it's not different. Because in a dependency case, if it's found that due process rights have been violated by the appellate court, and you know what? They don't look at the best interests of the child. They just look at the fact that the lower court did not give that parent the opportunity to be heard. They did something in such violation of that parent's rights that you're going to end up back at the drawing board. So the court doesn't care at that point, not that they don't care about children, but that is not a factor in their consideration of whether or not a case needs to be sent back. So that's why this is important. This is not going. Oh, there we go. And just like a criminal case, who has the burden of proof in a dependency case? Does anybody know who has it in the criminal case? The state. It's the same thing in a dependency case. So just like in a dependency case, the state has the burden to show that, that the parent did something that would amount to abuse, abandonment, or neglect. And does anybody know why our criminal and dependency system is set up this way to give the burden to the state? In very basic terms, of course, it's because we're dealing with fundamental liberties, and they're the ones saying that those liberties should be taken away. So of course they have the burden, but also in a broader sense, we never require somebody to prove their innocence because it's pretty much impossible to prove a negative. And you can't really prove you didn't do something, usually. So the state has the burden. If they're trying to interfere with a right, the state is going to have the burden, and we never require the parent to prove that they didn't abuse their children. And so it's the same thing. And does anybody know at what stages this burden of proof applies? Does it apply at shelter? Yes, it applies at shelter. It applies at the adjudicatory hearing. It applies at the termination of parental rights proceedings. It applies at all stages. The only time a burden of proof wouldn't apply to the state, requiring the state to have the burden of proof, is if the parent were to bring a motion on their own where they were trying to claim something. Right. So this is, oh, there we go. Okay. So everyone involved in the dependency system is fighting for a child's best interests, and so both parents and children, of course, have an interest in avoiding an erroneous termination, or even if the termination was right. If you didn't look at the due process of the parent from the beginning, you're looking at going back, even if you know you're going to get to the same result, and that's a lot of wasted time. A lack of reasonable efforts providing services to the parents in pursuit of reunification cheats the child out of a chance to be raised by their biological parents and may permanently alter the child's relationship with extended family members, especially if placed in foster care, and violations of due process result in delays, just like I said. So that is the biggest reason why we want everybody to understand that this is something you have to think of from the beginning, and it's not something to be glossed over. You should never go into a dependency case thinking that I know that this parent does not deserve to parent this child, so I am going to gloss over some things. I'm not going to give this parent an opportunity to be heard. I'm not going to go through the hoops because I know we can get to it quicker if we avoid all of that, because you're going to end up back at the beginning if a court found that that parent's rights were violated. And we want it this way. We always say in criminal, we'd rather let 10 guilty people walk free than convict one innocent person. It is the same thing. Most of the people in this room are parents, and we want these protections. So I just urge everybody to think about that in these cases. We're all in it for a noble cause, but understand that this applies to everybody. It's a constitutional right, and it's one of the most important ones that we have. All right. And the case that started it all, didn't really start it all, but it's the one that solidified it in the United States Supreme Court is Santosky versus Kramer. So if anybody is taking the board certification exam, I would say this is a good case to start with if you're doing your essay in juvenile, because this is the case that describes the fundamental interests of the parents, that the state must prove their case for termination of parental rights by at least clear and convincing evidence. There was a time where it was much less than that. The court found there is undisputed recognition that the freedom of personal choice in matters of family life is a fundamental liberty interest protected by the 14th Amendment. The fundamental liberty interest of natural parents in the care, custody, and management of their child does not evaporate simply because they have not been modeled parents or have lost temporary custody of their child to the state. So when the state moves to destroy weaken family bonds, it must provide the parents with fundamentally fair procedures. So the court found that this is a right that is so sacred to us that you don't have to prove it beyond a reasonable doubt in most cases, and that is weighing it against children's interests, because they know that we're dealing with very vulnerable people in this, so it's clear and convincing, but preponderance of the evidence was never found to be enough. So the factors to consider are the private interests affected by the proceeding, the risk of error created by the state's chosen procedure, the countervailing governmental interests supporting the use of the challenge procedure, and it says, in parental rights termination proceedings, the private interest affected is commanding. The risk of error from using a preponderance standard, which is what it used to be, is substantial. And the countervailing governmental interest favoring that standard is comparatively slight. Evaluation of the three Eldridge factors compels the conclusion that the use of a fair preponderance of the evidence standard in such proceedings is inconsistent with due process. So that's how we got to termination of parental rights being a clear and convincing standard. The court noted that both parents and the child share an interest in avoiding erroneous termination, as was said on the previous slide. This is for the parent and the child. For the child, the likely consequence of an erroneous failure to terminate is the preservation of an uneasy status quo. For the natural parents, however, the consequence of an erroneous termination is the unnecessary destruction of their natural family. A standard that allocates the risk of error nearly equally between those two outcomes does not reflect properly the relative severity. Two state interests are at stake in parental rights termination proceedings: a parent's parental interest in preserving and promoting the welfare of the child, and a fiscal and administrative interest in reducing the cost and burden of such proceedings. A standard of proof more strict than preponderance of the evidence is consistent with both of those interests. All right, I think you go ahead.
So when is due process triggered in dependency? Usually our first stages of our proceeding is a shelter hearing, which comes after the state interferes with either the care and custody of a child or the fundamental decision-making rights that a parent has. The state does have an inherent interest in protecting children from harm. Because of this state interest, the state authorizes the Department of Children and Families to remove a child from a home prior to any court order. However, within 24 hours, there must be a shelter hearing. For an adjudication of dependency, we have a higher standard of proof, and yet a higher standard of proof at a termination of parental rights trial. The more a state attempts to interfere with the parental right, the higher standard of proof they have to protect due process. At shelter hearings, must be 24 hours within that restriction of your access to your child. At the hearing, the state continues to have the burden of proof. It's our lowest standard of proof that we deal with. It's probable cause. It's more than a mere suspicion. But the court does need to find probable cause that either the child has been harmed by abuse, abandonment, or neglect, or is at imminent risk of harm, that the child has no legal custodian to provide care, or that a parent has violated a condition of placement. At shelter hearings, what rights do parents have? For those that attend shelter hearings, is there usually a lawyer present for any parent? Mixed answers to that. Some areas provide counsel at this first stage at the proceedings. Other areas don't. Some areas, if there's a weekend shelter, there might not be anybody there. Rural counties, there might not be anyone from the Office of Regional Counsel, from the rotation list. There might not be anybody there. What if a parent's not told about the shelter hearing? Could there be some due process implications for failure to provide notice of the shelter hearing? What if notice is provided but only an hour before the hearing and this parent does not have access to reliable transportation? Is that adequate notice? If not, what can we do about it? What can we do in that situation where there might be no dependency attorneys available apart from the state? The state always has their attorney present. So the parent has a right to receive appropriate notice of the time, date, and location of the shelter hearing. The state must make efforts to provide notice. If they're unable to contact the parent, they can place that on the record. If there have been no efforts made to contact a parent, what you can do to preserve due process is to request up to 72 hours for a shelter review hearing so that parents can be provided with appropriate notice so that they have an opportunity to appear and present evidence to try to dispel probable cause. They have the right to present a counsel. 39402 says parents have the right to counsel present at every stage of the dependency process. That includes the shelter hearing. This could be the most important hearing in the entire process because if the court does not find probable cause, that family gets to go home. So in areas where there's not attorneys present, schedules don't permit it. There are some attorneys that cover 4 different counties up in North Florida. You can't be at every shelter hearing that's scheduled within 24 hours. What can you do? You can request a shelter review hearing in 72 hours so that you can have counsel present for each parent at every stage of the dependency process. A parent also has the right to call witnesses and present evidence. They don't have that right if they don't receive notice. They can't very well have that explained to them without counsel present. So, examples of what can be presented at a probable cause hearing You can have a domestic violence counselor present to talk about the safety services that are in place that would eliminate the need to shelter this child. You can have a mental health counselor present to talk about the services that a parent is already participating in that eliminate the need for shelter, or to testify about their level of cooperation, as that's needed to have a safety plan to avoid shelter. So what about if a judge finds probable cause to shelter a child? Do you lose all your rights at that point? Because a judge finds probable cause to remove a child from your care, a parent does not lose their rights. They retain many rights, most notably the right to visitation. 39402 directs visitation to begin within 72 hours. There are reasons for that not to be ordered. However, this takes into account the trauma that is included with a removal from a family home. And unless there's clear and convincing evidence that visitation is not in the child's best interest, visitation should occur, should be as regular as possible, and should start within 72 hours. Parents have the right to provide relative and non-relative placement options to be screened by the department. The legislature has an interest in providing not just legal permanency, but emotional permanency to children. This includes keeping up these kinship relationships when appropriate. In our office, we have some examples we'll have up front. We have developed a placement and resource supervision list that we have our parents fill out at the shelter hearing, or if they're not able to be present at the first hearing they come to, so that everyone is on notice of who their preferred placement options are, whether they're appropriate for placement or just visitation at this time. Some relatives can't take in all the children, but they're available to supervise visitation. The more people you have approved for visitation, the more often and regular it can be, the less disruption there is to the child. We file these forms after our parents fill them out so that there's no lack of information sharing between the department and the investigative side and case management, who likely will be doing those home studies that were requested. It also gives you a really easy way to follow up on the requested home studies. You just reference the sheet that you filed. You remind the court at your hearings that we have filed the placement and resource supervision list. This is our preferred placement. We are requesting home studies. When you follow up about those home studies, makes it very easy to reference. Parent continues to have the right to attend medical and educational appointments, and the right to consent or refuse medical treatment, medications, and immunizations. If there is a disagreement, due process does not dictate the outcome of these disagreements. It merely provides notice and an opportunity to be heard. The right of a parent to object to potential changes of educational placements for the children. This is something that the Guardian Ad Litem program in our area takes very seriously. Oftentimes when you have a child that's placed outside the home, their school district may change. The state has to weigh the benefits that this child is receiving from their current institution versus the hardship to now be possibly transported an hour away to school. What you can do is request that if the child's at the shelter hearing, if it's the intention of the department to change the child's educational placement, that not be done without a best interest hearing. The department is required to ensure that the children are in the best educational setting for their needs. The child's best interest often depends on the length of time it now takes to go to the school. You have to take into consideration that it's standard tests that are given all throughout the year. How long is left in the semester or the year? When is an appropriate time for this child to change educational placements? Whether there's a 504 plan or any kind of educational plan that needs to follow the student. It is very important that everybody make sure that if the educational placement is going to be changed, that it is in the child's best interest and not merely out of convenience or placement, and that whatever resources that child had at the first educational placement follows that child. We run into situations sometimes where you come to your shelter hearing, you have a proposed placement, you file your resource placement and supervision list, you wait for home studies to come back, you have a dependency petition filed, you come to arraignment, and all of a sudden the placement's been changed. Perhaps even the school has been changed. What you can do at a shelter hearing is just request that if any changes are going to be made, that notice is provided, so that a best interest hearing can be had if there are disagreements over what is best for the child in educational placements and any placements.
Okay. Has everybody or anybody heard of the Simmons versus Perkins case? Raise your hand if you've heard of this. It's actually not a dependency case, and that might explain why a lot of you have not heard about it yet. But it's a very good case that Florida Supreme Court decided. And what Simmons versus Perkins did, it was a family case. Mom was married, but had a baby with another man while she separated from the father from her husband. The other man didn't know about the husband, and for about 3 years they raised this child together until they decided that they would separate, and Mom didn't want him to have anything to do. Thank you. Mom didn't want him to have anything to do with the child and decided to team up with the legal father in the case to try and squeeze out bio dad. And the legal father agreed. He objected to the bio dad have anything to do with the child. And in the common law, this bio dad would have been, in common law terms, screwed, basically. There'd be nothing that he could do. And you might have all seen this in dependency cases where you do have a bio dad and everybody knows he's the bio dad. But there's a legal dad there saying, sorry, I don't agree to that he's the bio dad, or if he is, I don't care, I'm not giving it up. Or maybe mom doesn't want the bio dad to have anything to do with it. And the court looks at bio dad, says, sorry, there's nothing I can do. You don't have any rights, you don't have a right to be heard, and you don't get a lawyer, and see you get out of my courtroom. And that's traditionally the way it has been. Simmons v. Perkins, that was just decided in 2018, held that paternity from a marriage is a presumption of legitimacy, and it can be rebutted. So presumptions can always be rebutted in theory, but this particular presumption was so intact that the courts have found that unless people agreed, there was really no way to rebut this presumption of legitimacy. And if the mother was married at the time the child was born, that legal father was the father, unless he agreed to step back. So the interesting thing, or not interesting, but the common sense thing that this court added was that why not do it if it's in the best interest of the child? And this court ultimately found that, well, they already knew that he was the biological father, but they found the father had been involved with this child for 3 years, had been providing support, had a relationship with the child, and the court found that it was actually in the child's best interest to have this biological father be the child's father. So the court held that the paramour had standing to rebut the common law presumption of legitimacy when he has manifested a substantial and continuing concern for the welfare of the child, and that the presumption is overcome when there's a clear and compelling reason based primarily on the child's best interest. Makes perfect sense. We are dealing with best interests of children all the time in dependency. Although this was a family case, the courts are starting to recognize this. It's a very difficult situation, though, right now, because there has been no implementing legislation for dependency in these cases. So a lot of courts are still taking the common law presumption. Does anybody have a case in their jurisdiction where the court has considered the biological father over the objection of the legal father? Has anybody had that? I see in the Eighth Circuit, you've had it happen before? Okay. And did the court give that biological father a lawyer? Yes. Did the legal father also have a lawyer?
The legal father was incarcerated.
He just said the legal father was incarcerated. I don't know why that would make a difference as to whether or not he would get a lawyer. That's for another slide, and we will get to that slide, but I have concerns about the due process of legal dad there. But, if the legal dad, appeared over the phone and said, look, I don't want anything to do with it, and bio dad was there.
Previously, he had been contacted and said, I want anything to do with it.
Okay, so he's saying previously he was contacted and he said he didn't want to have anything to do with it. Normally, if the legal dad says, I don't want anything to do with it, the bio dad says, well, I do, and mom says it's okay, the dependency court can very simply establish and disestablish paternity right there and then. And those situations are a little bit more simple, and it happens all the time. And so we do make biological fathers legal fathers through the dependency system, despite the presumption of legitimacy with the actual married dad. But that's when the parties agree. When the parties disagree, does anybody have a situation where the parties disagreed, but the court gave the biological fathers some standing, or at least heard him out? Has anybody had that situation? I know we've had it in the Eighth Circuit because we've talked about it.
Case where they terminated the parental rights of the grandparents and the child of the legal father and the legal mother, and then the bio dad stepped in.
Okay, so in Baker County, the grandparents had the child, and the paternal grandparents, was it the legal paternal grandparents? Maternal grandparents had the child.
The bio dads really much through his parents trying to interject.
And the bio dad, through his parents, I guess they paid for a lawyer for him maybe, try to interject.
No real connection with the child.
And the bio dad had no connection with the child in that case, but the court did hear him out?
Yes.
Okay, and was the legal dad objecting to that?
He had his rights terminated.
Okay, so he had his rights terminated. At that point, he had no standing. Right. Yeah, and in that case, they terminated the rights of a father, and post that, they were trying to say he never had any rights really to begin with, because there's a biological father saying, hey, I had rights. That creates a whole new set of interesting legal questions for both legal dad and bio dad. But it sounds like most people have not really been faced with the situation where you've got legal parents objecting and bio dad saying, hey, I want to be heard. And there's still not a clear way to handle this, but I think that these courts would be remiss if they shut out the bio dads like they used to do in light of this case, which says that these bio dads can have standing if it's in the best interest of the child. Of course, the problem we're going to face is these bio dads are not going to have a lawyer. So how are we going to determine whether or not it's in the best interest? We've discussed this in my circuit. I think if the court's aware of it, it would be prudent to hold a best interest hearing. And I think all parties should agree, because if you ignore bio-dad in light of Perkins, Simmons versus Perkins, if you ignore bio-dad and you go through your proceedings and you get all the way to the end and bio-dad at some point hires a lawyer and sues saying, you know, hey, I am the bio-dad, I try to claim my paternity and they shut me out completely, you might end up having to go back to the drawing board. So regardless of the fact that we do not have any implementing legislation, I think it would be best interest of the children and best interest of all the parties involved not to ignore the bio-dad. A best interest hearing is what I suggest. That's all it would take. Of course, the sooner the better. If you know about bio-dad from the beginning, do it right at the beginning. That bio-dad's not entitled to a lawyer unless that court, I think, makes that determination. That one, that he's the bio-dad, and two, that it's in the child's best interest to be involved. Now, some would say if he's the bio-dad, then disestablish legal dad and just let him do that. But I don't think that's where the law is right now. Yes.
What do you suggest in cases where you have mother and bio-dad, but legal dad is not around?
Okay. What do you suggest in cases where you have a mother and a bio-dad, but you can't find the legal dad? I think Simmons applies in that case. You have to do your diligent search. You have to look for legal dad. Give him an opportunity to be heard. Once he can't be found, I think at that point the court needs to make a best interest determination as to whether or not this bio-dad should be established as the father of this child and disestablish the legal dad. That is my legal opinion based on my reading of this case and where I think the law is going. It's going to come down to best interest of the child. So if we ignore that and we say, okay, we can't find legal dad, but we're going to ignore bio-dad because we can't get legal dad's agreement, you've got a dad standing right there, ready, willing, and able, you know, to step up to the plate. I think it would be remiss of the courts to ignore that father. Yes.
I had a case where the court did precisely what you said. Legal dad was found ultimately in Pennsylvania through a diligent search. He never made any efforts to come down. He got noticed. Bio dad could just step in. We had what the court called the prevent hearing and established the bio dad as the legal father of the child.
Okay, so she's saying that that was done in her jurisdiction, and they called it a prevent hearing, which I think that was a little legal wrangling there if it was done before this case, and she's agreeing it was. But you know, it sounds to me like at that point the court weighed, you know, the interest of the child and what is the likelihood of appeal by this legal father. But at this point, I think we do have good legal grounds to be able to do that regularly. Now, I don't know if the courts are going to do it. I don't know if the parties are going to agree. But based on where it seems things are going because of this case, I think it's prudent to go ahead and have that best interest hearing. Then you've given that biological father his due process, and even if the court has found at that point that it's not in the best interest to let this bio dad be involved, he's been a drug addict, he's been in jail, you know, whatever the reasons they find, at least that father can't come back later and say, I never had my opportunity to be heard. So I think it's prudent to go ahead and do that. Okay, and that's all I had to say about that case before Rachel. Did anybody have any other things that happen in their jurisdiction or comments about that or experience with that issue? Okay, we'll move on.
Time for my favorite, development of the case plan. So raise your hand if in your area a parent is involved in the process of developing the case plan. Half, maybe half. In the other areas where a parent is not involved in the process to create the case plan, what is the process? Do you just show up to arraignment and they tell you what the proposed tasks are? Okay, So in those areas, there's no signed case plan that everyone has agreed to and developed through. So do you think it's a good idea to involve parents in the development of this case plan with the services that they need to complete and the changes that they need to make to have their children return home? Why? Why is it a good idea to have parents involved? What does that change about the rest of the process?
I think you get a good read on their intent,
Okay?
just observing how they process what they want to do if it's chose that.
It tells a lot if they're able to comprehend what you're talking about, what's being asked of them, what's being required from them to have their children return. Why else? Yes.
You may find out more about what's going on, and also when somebody has a part of the decision-making situation, they are more likely to participate in it positively.
And maybe more accountable for the results. Yes, Mr. Kaufman.
More notice to the parent as part of their due process rights. They're getting notice, they're getting feedback, they're giving feedback. The arraignment process is so fast, sometimes it's 10 minutes, and you're talking to them 5 minutes before the hearing and saying,
Yep.
this is what they want.
Let's go ahead and repeat that, because I don't think the camera will have picked it up, and maybe some other people in the room. No, we'll repeat it. Go ahead and say what you said again, and we'll repeat it. The due process, the right of the parent to be heard.
Parents' due process rights are being protected because they're
The right to bring protected because they're there.
during, family team conference or whatever conference they have with the department.
Being there during the family team conferences with the department.
Due process because that the arraignment is very quick and they're talking.
Yeah, gives them more time, right, because at the arraignment, it's quick. And, they're put on the spot at the arraignment, but if they had all this opportunity to be heard beforehand, they can't complain that their due process rights were violated. We got some hands up. Sorry.
I would just argue that if parents are involved, the case plan is supposed to be better because you're less likely to get a template case plan. Parents can say, well, that's not relevant to me. I don't need that. I put them in before that didn't work. This might work. And so it's actually better for the parents and the kids if everyone's involved and there's an actual case plan that's based on the facts of the case.
So basically, you come up with a more relevant case plan that's based on the actual facts of the case if you have the parent involved. And I know in some cases, you're going to ask for a mediation or a case planning conference, but a lot of cases, just like in a criminal case, when you show up at arraignment, you want them to go fast, and they come up with a case plan, you go over it real quick with the parent, they accept it, you get into it, might not address the problems, one, and two, later the parent might complain that, look, I didn't even get a chance to talk about this. So it's always better to have them involved beforehand. Sorry, I interrupted.
Go ahead.
It's also in the event of a termination of parental rights. Many times the parent said, I didn't understand, I didn't do that task because I wasn't aware, and in this way, it facilitates because part of the case.
And she said that a parent can't come back later and say they weren't aware because they were part of the case plan process to begin with. So they're given notice and they're made aware from the beginning, as opposed to saying when you finally get to TPR that I didn't know I had to do that. Well, you were involved in deciding what to do. So, Marcy.
And then the department gets notice that the parent may have some barriers to their case compliance.
That's very important for all the parties to know if there are specific barriers that can be overcome with a specific, narrowly tailored service. Not all services are one size fits all. Some parents will need one-on-one individual parenting. Some parents will need individual batterers intervention program because they shut down in a group setting, because they have an anxiety disorder or post-traumatic stress disorder. So I think all those are very important. Accountability on both sides, narrowly tailored services, which is what we're supposed to be doing. That's what we're tasked with doing. For those who said yes, parents are involved in the case planning, are there counsels involved as well? That's great. What area is that? Okay. That's great to hear. So some of us might be surprised, others won't be, that parents have the right to participate in the development of the case plan face-to-face. not after it's developed and after they're just informed what the proposed tasks are. They have the right to participate in the development of it. And if it's something so small that can change the path of the entire compliance with the case plan, change the circumstances from which these kids were removed, that small change on the front end can make a world of difference in a lot of people's lives.
And I'm going to talk about this a little more later, but since Marcy brought up the word barriers, that's actually a new word that came into the law last session. A new statute just snuck by us last session where it required parents to let the court know of their barriers. And so they can be addressed. I mean, certainly it makes sense from a practical standpoint. If a parent knows about barriers, tell somebody so we can fix it, and it's very practical. The issue we're having, and the concern I have with the black letter reading of that statute is that this should never be interpreted to mean that a parent has the burden to prove their case. And so if that's the way any parties are looking at it, you are in danger of the case being overturned. A parent does not have to prove that they did something to address their barriers. It makes sense that they let people know about their barriers, and certainly they should do that, but it is never the parent's burden to come up with this and decide what they have to do. But certainly, if they're involved in the case planning from the beginning, and they know, hey, look, I don't have transportation, and I'm telling you that right now, it can be addressed quickly, and it could be rectified, and there you go, they've told of their barriers. But just be careful with that statute, because although it says that they should do that, you can't shift the burden. So I just wanted to make it very clear.
Go ahead.
So if they have the right to participate in the case plan, and it doesn't happen, and they get to court at arraignment, and they say, here it is, whatever, then the case can be overturned later? If they didn't have that happen?
So these are the protections that are built in to protect due process. And yes, I would say if the appellate court found that this parent did not get notice and the opportunity at each of these stages, that it can be overturned.
But let me also point out, they can waive any rights. So if, usually what'll happen if they consent quickly without having done that, the court is very careful, or should be very careful, saying, do you know you have a right to talk and have a case planning conference and have more time? You sure you don't need more time? You want to get all that stuff on the record, because if they say that no, I'm fine, I've had plenty of time, then no, they can't come back later and say, I needed more time. So if you're going to be quick about it, make sure they are understandably waiving those things. And that's something all parties should be concerned with, not just the parent attorney, not just the department attorney, but the court and the guardian ad litem attorney. You want people to know about that. Yes?
So parents have the right to participate in developing a case plan. Do they have the right to have their attorney present during that?
Yes, that is right up here, 39-611-1C, in case you can't see those colors from the back. Parents have the right to have legal counsel present during the case plan development.
Let me tell you, they can waive that too, but not if there is an attorney for another party present. So if the attorney for the department, I get to you just one second, the attorney for the Department of Children and Families is there, or the attorney for guardian ad litem, you can't come in and ask that parent, you want to waive your attorney just so you can go over this case plan, because if they say yes, that's going to be overturned right there. So, but if it's just the parent working with a caseworker, there's nothing wrong with that, but you got to be careful. Also, it's a violation of bar ethics rules, so you don't want to do that. So hold on, we had one over here, and I'll come back to you. And that's happened before. Yes, and if they choose not to come, then unfortunately what would have to happen at that point is the attorneys need to leave the room and let them work it out. They have to. You try to get the parent attorney there, I would call, at least have them by phone, but as attorneys in the room, it's your bar card at stake here, and so it might be frustrating that the parent attorney's not showing up, but if you're sitting there talking to them unrepresented, you're putting yourself in a bad situation. Yeah, hold on a second. Yes.
So the proposed case plan has to be filed 72 hours before the hearing, right? So
Let's just take a poll. How many areas do the case plans get filed 72 hours before the arraignment hearing?
Sometimes.
Not often. Yes, it does.
Right.
and then there's case plan conference, where you go over the proposed case plan, and that's where the case plan is actually developed, right? And the case plan conference in Orange County happens the morning of the arraignment, a couple of hours before the arraignment. And the parents, if they're, but also the child has a right to be there. Statute says that, right?
If appropriate. If appropriate. It's not right to legal counsel if appropriate.
She's talking about her case plan conferences are done on the same day as the arraignment? Right, so obviously your case plan is not going to get filed 72 hours before.
It does a lot, sometimes.
It's just,
And then we get it, and we,
yeah, how many minutes?
for the case plan conference,
Hold on, let me see how much time we have left, because I don't mean to cut you off, but there is something I wanted to get to. How much time do we have left? Is that 5 minutes?
No, not for time, sorry.
Oh, okay, all right, go ahead. I'm sorry, we have some time. Yeah.
what's trying to get to this is that, okay, so that if their attorneys don't show up, then we don't have the case plan conference, right?
Right,
We go in and we tell the judge, we couldn't have a case plan conference because parents' attorneys did not show up.
yeah, she's saying they couldn't have a case plan conference sometimes because the parent attorneys don't show up, and they tell the court that.
Right. And so but if everybody's there, that's where it's developed. And the parents have input, parents' attorneys have input, sometimes we disagree, we'd rather take it to the judge.
Right.
That sounds great.
Yeah, no, it's fine. If everybody agrees, even if the parent attorney didn't show up at that time and they come to court and they agree, last minute, if everybody's on board, it's fine. The problem is, when people don't agree.
Because that puts off permanent.
Of course, but,
The arraignment, and there's been no case plan conference,
yeah,
and we tell the judge we do not have a case plan conference, the remedy is to have a case plan conference and come back for arraignment.
right. And sometimes you do have to go to a case plan conference, come back and put it off a little bit. The clock, we all know, is ticking. Parent attorneys advise their client, the clock starts ticking whether or not we get a continuance or not. So they know about that. So it's the parents' rights. Right. Right, so it's the parents that have to understand that, and they're the ones who, are usually in a rush to do things. So you just want to make sure that they understand, and that if they're giving up their right to be involved in the case planning conference, that it's all done knowingly they had the opportunity for it. And sometimes they don't want the opportunity because they want to rush into it, and that does happen a lot. So, but you can't come back later and say I didn't have the opportunity if they knowingly gave up the opportunity. So, yeah, right.
So also at the case plan conference, a parent cannot be threatened or coerced with the loss of their custody rights in order to get them to agree to this case plan. It has to be knowing and voluntary. The judge usually goes over that, at least in our areas, with the parent if they're accepting the case plan. Also, what's very important is that participation in the case plan is not an admission of any abuse, abandonment, or neglect. We have run into issues lately where, although you're not admitting anything in the development of the case plan, or even in accepting services, even in voluntarily engaging in services prior to an adjudication of dependency. However, that might become an issue if you don't admit to what they're accusing you of. How are you able to move forward in services? So we've been really working on these conditions of return, working with service providers on conditions of return, what needs to be shown, not what happened. Because we're dealing with conditions of return, through the services that are being provided in a case plan to work towards reunification. We're not here in criminal court. We're not here for any punishment purposes. When your goal is reunification, you're working on conditions of return and having children return home.
Am I in the way? Oh, I want to go ahead and.
Due process for incarcerated parents.
You mind? I just wanted to talk about this one real quick because I know we're short on time, but I just wanted to tell everybody. So this is a new statute that was Alan Abramowitz and I drafted this last year, 39.6021. It was his idea, but it was drafted in really direct response to the court's finding that due process rights of parents who are incarcerated were being violated, and they'd get all the way to the end of a case and all the way to a TPR, and yay, the father's in jail, we terminated the mother's rights, let's adopt this kid. The cases were coming back, and everybody had to start from square one because parents that were incarcerated were being ignored. So I don't know, since I haven't been in the courtroom regularly since this statute was passed last year, I don't know how the courts are dealing with it. But basically it codifies the responsibility of the department to make sure that if a parent is incarcerated, that they are involved just as if they were not incarcerated. Obviously, to the extent possible, it requires the department to look at asking that an incarcerated person get transferred to a place where services are available, that the incarcerated parent participate in the case planning to the extent possible. And if the parent is to be released before the case plan expires, the case plan must, if appropriate, include tasks to be completed upon release, because the court or the department or whoever they were not doing these things. People who were in jail, they figure, they don't have to provide services. There is a duty to provide services, even if a person is incarcerated, and even if they get incarcerated during the pendency of the case. Now, of course, there's exceptions to this. Somebody who's going to be incarcerated for a substantial time of the child's life, somebody who would never be able to complete services. But what about if that parent who is incarcerated is a non-offending parent? And they'll be there for a year, which is how long we have in these cases. What about those situations? You think it's okay just to terminate because somebody's in jail for a year on a DUI and the mother abused, abandoned, or neglected the child? So what do you all think about that? I mean, does that father deserve to have his rights terminated because of a DUI? The answer, the courts are going to say no. So you probably need to, not ignore that parent just because he's in jail for a year on a DUI. Well, certainly, there's all sorts of other factors. The question was, what if he's been jailed several times before? Now, the petition needs to make allegations if they think that is something that puts the child at risk. Certainly, the petition would have to make those allegations. But you have to give him an opportunity to do services. You can't just say, oh, well, his sentence is a year, so let's not give him services. Unless it was going to be an expedited TPR or something like that where you're not required to provide the services. So don't discount it just because somebody's in jail, even if they're going to be in jail for a year. Did I say pretty much what we were supposed to say?
How many areas are actually seeing the lists of available services at whatever location a parent is incarcerated at? Are we seeing any of those? Seeing some, okay.
My question was, is there a level of, let's say, you can refer to the father who's in prison for years. Let's say the child is 5 and he's got 8 to 9 years. Will they still involve him because he's not going to be part of the child life?
Okay, so the question was if the father's in prison for, say, 5 to 9 years, and the child is a young child, and do they still have to involve him if the mother's working on her case plan, correct?
Or even if they think of a TPR, what rights?
Well, and that's sort of two different paths. In my opinion, if the mother is working on her case plan, and the father's rights have not been terminated, and they're not going to do a one-parent termination of parental rights, and he wants to participate in services, you provide him services, even if you think he's not going to be out. Because you know what? The mother might get the child back. The father might get out at some point, so he's going to be the father anyway if the mother doesn't lose her rights. And if you get all the way to TPR, even though he's in prison for 5 to 9 years, if you didn't provide him any services, he has an appealable issue, and you're going to have to start over. So that's my thought on that one.
So after our case plan development, after our shelters, we go to arraignment. We've got due process protections at arraignment as well. So after shelter, the dependency petition has to be filed within 21 days. Must be served on the parents with, again, notice of the arraignment hearing, which usually is provided at the shelter, but there could be various reasons why it wasn't. You have to have 72 hours notice. Practical implications, you can ensure at the arraignment hearings, you can check your docket line, you can ask the department to place on the record whether a parent was served, when service occurred. A lot of our courts we'll pull up the summons and see when and where a parent was served. If the department has not filed a return of service and can't tell the court whether or not a parent was served, you can request that a default not be entered, up till they file proof of that service. The reason for these time frames are very important. We have to then go to the arraignment hearing no later than 28 days after the shelter hearing. The reason why we have to abide by these time frames is because of these fundamental due process rights. The state can only hold your child out of your custody based on a finding of probable cause for so long. Where would we be if the state could hold your child out of your care and custody for 60, 90, 180 days based on just a finding of probable cause? Remember, the higher the state interference with your custody rights, the higher burden they have to show, the more due process protections there are. You can make filings for demand for early filings. If it's a situation where you feel that probable cause was iffy at best at the shelter hearing, and that this child, parents, and family are going to suffer from this removal, which there is trauma related with each and every removal, you can file your notice, demand speedy filing of their petition, come to court, request your adjudicatory trial, which is supposed to be held within 30 days of the arraignment hearing so that you can protect your client's due process rights in a timely fashion. How many attorneys actually have adjudicatory hearings set within 30 days of the arraignment hearing? That is very few hands. Very few hands. What are the reasons for that? We've got a backed up trial calendar. Do you mean set or held? I don't like that at all. Well, first witness called when the trial begins. I don't think it says anything about when it has to end. So in your area, do they set trials within the 30 days and then do a motion to continue? Yes. Does that happen regularly?
Yes. And it's not always a written motion.
For continuance? It's not always a written motion for continuance, okay? So those have really strong implications for a parent that is actively seeking a trial to challenge the allegations contained in the dependency petition. Go ahead.
I'm just going to throw one more wrench into it. It's not always that the state, the CLS is in the court because the court time is setting them out. I was standing up, I'm guarding the 30, I'm for the
So what we're talking about is a potential delay of up to 7 months before a case even gets to be heard at adjudication. We're pretty strict on that in our circuit. That does not happen very often and without great cause. But as a guardian attorney, you know, where does that leave you with trying to have a speedy trial to resolve these issues? But it's not the due process of the guardian ad litem program that the rules are meant to protect.
Right, they're not in danger of losing their rights.
And that is true.
Yes.
However, there's child's right to timeliness as well.
Of course, and that's why the courts rush it through, and because the courts take into consideration the children. We only have 10 minutes left. I do want to go over real quick the statutory changes that just happened this past session. So if we're going to skip over these for now, there's so many more things I wanted to talk about, even, you know, ineffective assistance of counsel, all of that stuff that the courts are finally starting to recognize that even parents have a right to effective counsel as opposed to just somebody standing there next to them falling asleep. And certainly there's some other due process cases. We can send you these sites if you're interested. But I do, let's see, it's on, what page is it on? Is it after this one?
Quickly, as we go through this, family finding is a really fun statute to look through. Go ahead and take a look at it. It really talks about the legal and emotional permanency for children, how children are benefited by having relatives in their lives being placed in relative placement, and it places duties on the state to seek out biological family for the best interests of the child.
Exactly. And certainly, you know, we're looking at rights of parents because that's what Chapter 39 is about, but certainly, you know, it doesn't mean we're not thinking about the children. Even our clients want what's best for their children, believe it or not. But really quick, I wanted everybody to understand that, you know, Chapter 39 is continually changing. There's always new things filed. And Alan talked this morning about Senate Bill 262, which is probably one of the biggest changes to Chapter 39, but it sort of advances upon that barrier issue that came up in last year's statute that we were concerned with. But this statute talks more about what the court's obligation is to advise the parent that they need to talk about what their barriers are. It needs to be part of the case planning conferencing. The statute was also created to sort of push people along. Now there's only 7 days to make referrals once the case plan is agreed to. So it requires some other things, and there's a lot of different citations within Chapter 39 that this touches, but it does make several different changes that you'll want to look through in the next when the next statutes come out. And then Senate Bill 318 is just a public records one. I'm not going to waste any time talking about that. But House Bill 1209 basically created a legal fiction, because what they called it was a foster parents' Bill of Rights, I believe is what they called it. And so, of course, foster parents don't have rights, quote unquote, in Chapter 39 because they're not in danger of losing a fundamental right. So to give them rights through statute is really, as I said, kind of a legal fiction, but it does put obligations on the department to treat them with dignity and respect, include them in sort of the stuff they do need to know, because a lot of caregivers were not being told about certain things. But the important thing about this is that everybody needs to understand, just because they're calling it rights, they are not rights. They never trump the parent's rights. If the parent is saying they don't want their child to go to that particular doctor or that particular daycare, that is their right to say. You know, unless the court overrides that, you can't say, well, the foster parent has rights too, and the foster parent wants them to go there. That would be a bad argument to make. That might set you up for some sort of due process argument later on. So, so just be careful when you know you're looking at these statutes. 7099. This makes changes based on the Title 4E and funding. The Title 4E was funding that the Department of Children and Families was getting through Federal Act, and that waiver is going away. They're going to have to figure out different sources of funding, so I believe that was created in response to that. And then 5003 was also has to do with funding. One that is not on here, I don't see it, oops, wrong way. Maybe it's at the bottom. There it is. Senate Bill 124. Alan did talk about it this morning. That actually makes changes to Chapter 985, which is the delinquency statute. And what it does is it requires the court to consider the guardian ad litem report if a child also in dependency and is about to be committed to the Department of Juvenile Justice. The guardian needs to be able to give input in those. Now, in our jurisdiction, the guardian is there anyway giving input, but this codifies the duty of the court to make sure they take that into consideration. So that's a pretty good thing, I think, for the courts to do. Did you want to go back to anything? Or since we only have 5 minutes, so does anybody have any questions about anything we said? Interesting due process things that have happened in their jurisdiction or anything else that, oh, yes, go ahead.
If DJJ has to let the guardian ad litem know about, like, special hearing on something.
The question is, does DJJ have to let the guardian ad litem know?
No, that's not the question.
Oh.
Know that. Do we have to let them know about one of our hearings?
Does the guardian ad litem have to let DJJ know about one of their hearings? It doesn't go both ways, as far as I understand. I don't often see DJJ in dependency court, and I do not believe this creates an obligation for DJJ to be there in dependency court. The guardian's already there and will advise the court, or should advise the court, as well as the caseworkers, about the child's delinquency status. I think just as a practical measure for children, because I do represent children as well, as a delinquency attorney also, the child's lawyer should be also at dependency court, especially if the child is there. Now, there are some jurisdictions that do that. They're crossover courts, and they do have lawyers there for the children, but it is not that way in every jurisdiction. Our jurisdiction does not have it. A lot of times the attorney will show up. It's best practice, certainly, to make sure whenever your client is appearing in court that you're there for your client. So that is something to consider, at least for the child, to protect the child's due process as well. So any other? Oh, yes, sir.
One of the early issues, I've never been, I have to go to a case planning conference, but I'm told that I shouldn't come because that way the office attorneys will have to come also. They don't want me to come.
And you're an attorney, sir? Okay. He said he's been told not to come to case planning conferences because if he comes to case planning conferences, then all the attorneys have to come to the case planning conferences, so just let them work it out. I've heard that before myself. Yes. And a lot, yes, and he's saying, so he just asked for mediation at the arraignment, so the parents and the attorneys basically have to be there. I think that's a common issue. And sometimes the parties do work it out without attorneys. But really, I think as a parent attorney, you want to talk to your client about that. I'm not comfortable with it, as a parent attorney. Sometimes we don't even know that those conferences occurred until the parent gets to court. But there's nothing in violation of bar rules if there are no other lawyers there, and that's why they say, well, if you're going to go, then we're going to have to go, because everybody who's represented has to have their attorneys there if one attorney goes. So, dependency is a little weird animal that way, that people do a lot of stuff without their lawyers, but, things have to move along. You just want to make sure your client's rights are protected, so. Anything else? All right, well, thank you all so much. There's our website. You can find our emails on it. Thank you.